Gary Wall here, and this is Bridging the Week for November 10th to 14th, and today is November 17th, 2014. Good morning! Long anticipated enforcement actions and fines against a number of leading financial institutions involving allegations of attempted manipulation of foreign exchange benchmark rates were finally brought by the Commodity Futures Trading Commission, the UK Financial Conduct Authority, and the Office of the Comptroller of the Currency. However, the insight of one new CFTC commissioner regarding the efficacy of the agency's approach to the execution of swaps, presented in a prepared speech he never was permitted to deliver, also was notable this past week. There was a lot going on last week, including the initiation of new requirements for futures commission merchants regarding the handling of certain customer funds, so let's get started. The Commodity Futures Trading Commission and the UK Financial Conduct Authority brought enforcement actions against 5 financial institutions for attempted manipulation of foreign exchange benchmark rates. For most of the firms, the attempted manipulation is alleged to have occurred from 2009 to 2012. The 5 firms were Citibank, HSBC, JP Morgan Chase, Royal Bank of Scotland, and UBS. Collectively, the banks paid over $3.1 billion to resolve these complaints, $1.4 billion to the CFTC, and $1.7 billion to the FCA. Separately, the Office of the Comptroller of the Currency also levied aggregate fines of $950 million against Bank of America, Citibank, and JP Morgan Chase for foreign exchange trading improprieties from 2008 to 2013. According to the CFTC, the accused firms, through certain of their traders, endeavored to benefit their own trading positions and trading positions at other firms by attempting to manipulate and aid and abet other firms' attempts to manipulate certain FX benchmark rates. According to the CFTC and FCA, some of the alleged FX benchmark rates manipulation occurred while the accused firms were aware that regulators were investigating attempts by banks to manipulate the London Interbank Offered Rate and other interest rate benchmarks. Both regulators provided examples where the firms were advised of aspects of this misconduct, in one circumstance through whistleblower reports, but did not adequately follow up at the relevant time on these leads. In a speech published but not delivered, J. Christopher Giancarlo, one of the new CFTC commissioners, roundly criticized the agency swaps trading regime last week. He claimed that the Commission's swaps trading rules are flawed, contrary to plain language in the Dodd-Frank Wall Street Reform and Consumer Protection Act, and causing non-U.S. persons to avoid engaging in swap transactions with U.S. counterparties. Mr. Giancarlo had prepared a speech for delivery before the CEFCON conference sponsored last week in New York City by the Wholesale Markets Broker Association, Americas. However, he was precluded from delivering his speech under a 2009 White House ethics order because of his prior association with the Brokers Association. He was not able to obtain a waiver to give his presentation. In a nutshell, Mr. Giancarlo observed that while Dodd-Frank requires most cleared swaps to be executed on designated contract markets or swap execution facilities, it permitted CEFs to organize flexible methods for execution using quote-unquote any means of interstate commerce. The CFTC corrupted Congress's objective, claimed Mr. Giancarlo, when it limited methods of execution on a CEF to an order book or an order book and a request for quote system with a minimum of 3 participants. The CFTC also misread congressional intent and the plain language of the statute when it distinguished between required and permitted transactions, said that block trades must be executed off CEF as opposed to on CEF, and tried to require the execution of swaps subject to mandatory trading on a DCM or CEF, even when part of a so-called package transaction. As a result of the CFTC's flawed approach, concluded Mr. Giancarlo, there have been many unintended results, including fragmented market liquidity. The CFTC's Division of Swap Dealer and Intermediary Oversight again delayed the application of transaction-level requirements by non-U.S. swap dealers who engage in swaps with other non-U.S. persons when the swaps are regularly arranged and facilitated by employees or agents located in the U.S. The CFTC previously had taken the view that such activities conducted within the U.S. by such persons would cause the non-U.S. swap dealers to have to apply with certain transaction level requirements. Staff's latest relief expires on September 29, 2015. Separately, the CFTC's Division of Market Oversight granted a further delay to the application of the Commission's trade execution requirements in connection with a swap portion of so-called package transactions that would otherwise be subject to mandatory trading on a designated contract market or a swap execution facility. The new relief has various expiration dates for 6 different types of package transactions and the methodology of execution, ranging from May 15, 2015 to February 12, 2016. Rosenthal Collins Group, a CFTC registered futures commission merchant, was fined $700,000 US and required to disgorge over $100,000 US in commissions it earned in connection with activities of a duly registered associated person that worked outside of the firm's offices at the other FCM that also sponsored him, contrary to Rosenthal Collins' policies. The CFTC also cited Rosenthal Collins for permitting the same associated person to arrange swap transactions for the other FCM, where the counterparties apparently had futures accounts at Rosenthal Collins that he helped to open. The CFTC charged Rosenthal Collins with failure to supervise because of this activity. And finally, the Financial Industry Regulatory Authority seeks comments on a proposed rule modeled after a similar Securities and Exchange Commission regulation that seeks to prevent investment advisor retention by government entities based on political contribution, so-called pay-to-play practices. Comments to FINRA's proposed rules are due by December 15th. Well, that's it for this week's Bridging the Week. As always, there is more information in each article and more articles on the article version of Bridging the Week on the website. Check it out. Until next week, this is Gary DeWall. Have a great week and ciao!